Welcome to Dr. Jae Francis YouTube channel. If you're waiting for your work permit after filing for asylum, you need to hear this out. One incorrect move, like missing your biometrics appointment or rescheduling your interview, could stop your EAD, Employment Authorization Document, clock cold. This means delays in getting your work permit, and in some cases, you may become ineligible altogether. Hi, I'm attorney Jae Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. In this video, I'm going to break down how the 180-day Asylum EAD Clock works, what applicant-caused delays are, and how to avoid costly mistakes that can jeopardize your employment authorization. Number one, can asylum seekers get work authorization? Answer is yes. Asylum seekers can get work authorization, but only if specific requirements are met. To qualify for employment authorization document, we call it EAD or work permit, you must first file a complete Form I-589 asylum application. You can either file this form online or submit it by mail. Once your application has been pending, key point, for 150 days with no applicant-caused delays, another key point, you become eligible to apply for EAD under category C8, another important one. So to repeat a little bit, you're not eligible to apply for EAD right away. You need to wait 150 days after either USCIS or Immigration Court receive your 589 application. And then when you submit your EAD application, you need to select category C8. Also, important consideration is that USCIS cannot issue the work permit until the application has been pending for full 180 days. That is tracked by what's known as Asylum EAD Clock. Once your asylum application has been pending for at least 150 days with no applicant-caused delays, finally, you may file Form I-765 Employment Authorization Application under the category C8. For now, there is no filing fees for initial EAD application. We're just talking initial EAD application. And EAD is currently valid for 5 years for now, 5 years. Now, be aware that EAD work permit remains valid only when your asylum application is pending. We have noticed recently that especially USCIS, if you have an affirmative asylum application, they're really fast to schedule interview. And if they ever deny your case, even before reaching out 150 days, then you're not getting any work permit. So just be aware. Do not assume that your affirmative asylum application with the USCIS will take forever, and then you'll get your work permit for sure if you file your asylum application. So then key point is this. unless you have a good asylum application, you should not apply. Because number one, as I explained, you may not get your work permit. And number two, when USCIS doesn't approve your affirmative asylum, they're going to refer your case to immigration court. Thus, you start defensive asylum application. So be aware. Affirmative asylum application schedule for interview really fast nowadays. And then also, really important to know that if your asylum is denied and no appeal or remand is pending, your EAD, even though you obtain EAD already, will become invalid. So just another key point. And the final one, right, about this EAD application is that USCIS retains a discretion and may issue a shorter validity period in some cases. But right now, 5 years is a new standard maximum. But under Trump, they may shrink down to or revert back to 2 years. We'll keep you posted if this ever happens. Number two, what is the 180-day Asylum EAD clock? The 180-day Asylum EAD clock is the timeline USCIS and Immigration Court use to determine when you become eligible for work authorization. So key concept. Once you accrue 180 days on the clock with no applicant-caused delays, then you become eligible to receive your EAD while your asylum case is pending. So once again, if your asylum case is denied, then you don't become eligible, and then you may lose your validity period. Your EAD will become invalid unless you appeal to BIA. So, but that's not the scope of this conversation today. For applications, for asylum application, filed with the USCIS, I mentioned it's an affirmative asylum case. The clock starts the day your complete asylum application is received by USCIS. But if your case is referred to immigration court after USCIS refused to approve your affirmative asylum case, then EAD clock continues as long as there is no delay caused by you. So when your case is transferred from USCIS to immigration court, and then as long as there is no delay caused by you, EAD clock continues. Same with BIA appeal as well. In contrast, for cases filed with the immigration court, the clock starts when the court receives your complete application. So same, right? But some of you, they receive NTA, notice to appear, and then you started with immigration court for your asylum application instead of started with USCIS and referred to immigration court. So, two different variations when it comes to filing asylum application with the immigration court. But that one that I'm talking right now refers to those of you who file asylum application with the immigration court from the beginning. Importantly, under the current policy, right? So just be aware that asylum application, especially asylum EAD application, policy change over time. So you need to be aware. You need to follow most current policy. Asylum seekers who are unaccompanied children or those who change the venues will not lose the time on their clock. Very important. Just because of those procedural issues. So you may wonder what stops the clock. critical topic. Any delay that you, your attorney, or your dependent causes, like rescheduling interviews or missing appointments, will cause the clock to stop. What keeps it running? Key point: time during which your case moves forward without delay caused by you. So let's talk about the details. Let's talk about some examples that may cause your clock to stop. Number 3, what stops the 100-day, 180-day Asylum EAD clock? Let's talk about the most common applicant-caused delays that can stop your EAD clock. I'm going to list common scenario. Missing your biometrics appointment, capturing your fingerprints, rescheduling or failing to appear at your asylum interview. Critical. If you fail to appear for your asylum, your application could be also denied. The requesting a change of interview location. Showing up without a competent interpreter. If you don't speak English well, that can be an issue. Failing to appear to pick up your decision when required. I mean, not all the time, but it'll be mailed to you, but sometimes you'll be asked to come in person to pick it up. If you're in immigration court, right? If you have a pending removal proceeding with the immigration court and request a continuance or file a motion that delays proceeding, removal proceeding, that can also stop the clock unless delay is attributed to the court or DHS. So I'm going to give you 2 different examples. One example is caused by the court. So you're scheduled to attend your master calendar hearing, scheduling hearing, and then you got a notification that your assigned immigration judge didn't feel well, so cancel the master calendar hearing, reschedule to next time. This was caused by immigration court, thus it does not stop your clock. In contrast, you have a hard time finding attorneys. And then when you hire attorneys say that I need more time for your case. So you ask the court, either you or attorney, ask the court to reschedule. It's called continuance. Then immigration judge usually will honor this motion for continuance. It means they're rescheduling your master calendar hearing. But unfortunately, because this is caused by you or your attorney, EAD clock will stop from the date the continuance is granted. So when this motion for continuance is granted, your EAD clock stops. It will not resume until your next scheduled hearing in most cases. So you need to talk to your attorney if you have one regarding this matter. So rescheduling, delaying your hearing will stop your EAD clock. But there's a good news. Meanwhile, a change of venue request does not automatically stop the clock. When a defensive asylum applicant moves out of a state where their case began, let's say you started in New York, and the case must be transferred to immigration court in new location, let's say Chicago, right? So that must be changed. It's called change of venue. This change, right, does not stop EAD clock under new policy. So this new policy helps ensure applicants aren't unfairly penalized for routine procedural steps. In fact, you need to change your venue or location of immigration court per regulation when you change your state residency. You're following the rule, thus you should not be penalized for following the rule. Number 4, why this matters for asylum seekers. The EAD and work permit gives asylum seekers legal right to work. Not only that, you get social, but as I explained in other video, you don't get social via mail. You need to visit your local social security office to obtain a social security under new direction. But just be aware, right? When you apply for 765 application, there is a section say that would you like to apply for social security and mail to you? Obviously still there, but the USCIS and Social Security Administration is not administrating that option anymore. So you need to visit local social security office to get it. Anyway, so you need EAD and social security to support yourself and your families and gain stability while waiting for your case to be adjudicated by either USCIS or immigration court. More than ever, having a work permit function as your identification. You probably know that when you have a valid employment authorization, social security, you're eligible to obtain state ID or driver license as well. So the critical elements of living in the US. But that benefits hinges on how your EAD clock is calculated. So it's not straightforward. And then if you make any simple mistakes, it's going to complicate that. So delays, even unintentional ones, sometimes you don't know, sometimes it just happen, can cost you valuable time and even render you ineligible for work authorization. By understanding what actions affect your clock and knowing your rights under Garcia Perez settlement, that's the court case, you protect your path to lawful employment in the US. If you found this video useful, hit the like button and subscribe for more in-depth immigration guidance. Share your experience with EAD delays or clock issues in the comment below, and your story could help others. I hope that 180 days honored by Trump administration, that's something that we need to monitor. Thank you so much for watching this video, and peace be with you.